The fluorescent lights hummed with a cold, unforgiving precision over the set. This wasn't the ornate majesty of the Supreme Court. This was a crucible of petty claims and raw emotion, designed to deliver judgment swiftly, often brutally. But today, the air felt different, thicker. It carried the faint metallic scent of impending conflict, the kind that arises not from passion, but from calculated malice. He walked in with the aggressive swagger of a man who believed the system was his playground. Arthur Finch, a self-proclaimed personal injury lawyer from Manhattan, clad in an expensive, perfectly tailored suit that looked slightly too tight across the shoulders, radiated entitlement. His case was simple: a minor parking lot collision, exaggerated with theatrical indignation into a $7,000 claim for emotional distress and loss of professional opportunity. The damages themselves, a mere scuff on the driver's side bumper, were negligible, but the financial demands, buttressed by Finch's loud, aggressive presentation, were anything but. Finch launched his offensive immediately, a rapid-fire assault of legal jargon designed not to inform, but to overwhelm and intimidate. He spoke past his client, past the camera, directly addressing Judge Judy with a patronizing familiarity, as if sharing a joke with an equal he secretly considered an inferior administrator. He dismissed the actual physical damage as utterly irrelevant compared to the systemic injustice he allegedly suffered, characterizing the incident as an act of reckless disregard for professional safety and New York traffic statutes. Standing opposite this storm was Mr. Sterling. Sterling was unremarkable in every physical sense. An inexpensive but neatly pressed gray suit, simple wire-frame glasses, and a careful, deliberate demeanor. He was the plaintiff in this farce, the man Finch was attempting to extract $7,000 from. Sterling did not move. He did not interrupt. He did not fidget with his hands, which were clasped loosely in front of him. His face was a study in absolute stillness, a remarkable, almost defiant contrast to the gale Finch was whipping up. Judge Judy, famous for her intolerance of gamesmanship and theatrical dishonesty, watched. She leaned back slightly, her expression unreadable, a statue carved from judicial patience. She knew the type of attorney Finch represented, the type who mistook volume for substance, who relied on the fear of the small claims court setting to push through a fraudulent settlement. She was waiting for the moment Finch would inevitably overreach and hang himself on his own thread of arrogance. Finch, sensing that the usual theatrics weren't drawing the anticipated sharp rebuke from the bench, decided he needed a knockout blow. He needed to establish incontrovertible legal authority. He produced an exhibit, a printed annotated section of the New York State statute reference concerning contributory negligence in commercial parking facilities. He slammed the paper onto the lectern, the sound sharp and jarring in the contained acoustic space. "Your Honor," Finch declared, his voice rising to a crescendo of feigned outrage, "the defendant here violated Title 19, subsection C, paragraph 4, which clearly stipulates the requirement for maintaining a 12-foot clearance boundary when exiting a designated vehicular travel lane, regardless of the pedestrian or vehicular traffic volume. His negligence is not just a monetary liability, it is a demonstrable failure to uphold the safety requirements of the state, punishable by maximum punitive damages allowed by this court." Finch paused, chest inflated, scanning the room for the expected acknowledgement of his genius. He had twisted the text. He had read it aloud, emphasizing specific clauses, shaping the statutory language to suggest that Sterling had violated obscure NYC traffic codes even while stationary, creating the conditions for the collision. He concluded with a triumphant, expectant flourish. Then came the silence. It was not a friendly silence, or a hesitant one. It was a heavy, absolute silence that settled over the courtroom like freshly fallen snow, insulating the microphone from every sound except the faint, steady breathing of the participants. Finch was still vibrating from his own performance, his mouth slightly open, ready to parry the inevitable attack. But the attack did not come from the judge. It came from Sterling. Sterling adjusted his inexpensive tie, slowly, deliberately, using the movement to take another controlled breath. He did not raise his voice. He did not rush. He waited until Finch had fully exhaled, until the arrogance had begun to curdle into anticipation. When he spoke, his voice was measured, remarkably low, demanding that listeners lean in to catch the nuances. He didn't debate the statute Finch had read. He did something far more devastating. He acknowledged the statute, confirmed the title and subsection number, and then quoted the very next unread line. "Your Honor," Sterling began, his gaze steady, fixed on the judge, never wavering toward Finch. "Counsel is correct in citing Title 19, subsection C, paragraph 4. That is the controlling statute for commercial parking facilities in New York City. However," and he paused, letting the single word hang in the air, a tiny, lethal dart. Counsel neglected to complete the paragraph. "If Your Honor will observe the text, paragraph 4 continues into the qualifying amendment, which is crucial." Sterling did not consult a note. He did not fumble for the paper Finch had just used as a weapon. He delivered the counter-argument from memory, verbatim, in the quiet, precise cadence of a highly skilled engineer discussing specifications. "The statute continues," Sterling quoted, his voice maintaining its neutral, almost academic tone. "Unless the designated travel lane borders a facility operating under a specific certificate of occupancy classified as 14B, requiring a mandatory 5-foot encroachment to facilitate ADA-compliant cargo loading." He stopped. The court was motionless. "Your Honor," Sterling continued, slightly lowering his tone, injecting a hint of regret into the factual statement. "The specific lot in question, the one designated in Exhibit A, operates under Certificate of Occupancy 14B. The 5-foot encroachment is not negligence. It is, in fact, a mandated safety requirement for that specific building." The implication hung in the air. Finch had not just misquoted the law. He had stopped reading precisely at the point where the exception clause began, the clause that explicitly protected Sterling in this exact scenario and rendered Finch's entire punitive argument void. He hadn't overlooked the counter-argument. He had actively attempted to conceal it. The camera, hypothetically, held tight on Finch's face. The arrogance shattered, the confidence drained away, leaving a mottled white where confident pink had been moments before. His mouth worked silently, attempting to form a reply, a rebuttal, a defense. He sputtered, reaching instinctively for the document he had slammed down, as if checking the text would somehow magically erase the words Sterling had just spoken. He couldn't speak. He couldn't articulate the legal maneuver because there was no maneuver left. Sterling hadn't debated the facts of the accident. He had simply revealed the inherent procedural fraud embedded in Finch's preparation. He had used Finch's own chosen document, the authoritative state statute, as the precise tool for Finch's intellectual destruction. Judge Judy leaned forward then, her gaze cold and utterly focused on Finch. Her voice, when it finally cut through the heavy silence, was not loud, but it was edged with a dangerous, surgical precision. "Counselor," she stated, using the professional address with visible contempt, "you brought the statute. You read the statute. Did you neglect or did you willfully omit the operative clause that directly negates your entire liability claim?" Finch stammered. "Your Honor, I was focused on the primary motion of the vehicle. "I don't care what you were focused on." Judge Judy's voice cracked the stillness, sharp and definitive. "You brought a document into my court and misrepresented its contents to seek punitive damages against an innocent party. This is not a technical error, Counselor. This is advocacy bordering on, if not achieving, ethical violation. You attempted to use the rules against someone who simply followed them." She turned her attention to Sterling, the tension in the room easing subtly, like a taut wire finally being slackened. "Mr. Sterling," she said, her tone softening fractionally, "you are clearly familiar with the regulations governing that particular commercial zone. May I ask how you obtained such precise, detailed knowledge of the certificate of occupancy requirements?" Sterling maintained his steady composure. "Your Honor, I live 2 blocks from that facility. When I received the claim and realized Mr. Finch was misrepresenting the extent of the damage, I did what any reasonable person would do. I prepared. I went to the municipal building archives, pulled the zoning codes, and verified the CO 14B designation. It took 3 hours and 27 minutes. I felt it prudent to ensure I understood the rules I was being accused of violating. This was the core of the victory. Sterling hadn't hired expensive legal counsel. He hadn't resorted to emotional arguments or petty recriminations. He had defeated high-priced arrogance with simple, meticulous homework and respect for the bureaucratic process. He had weaponized diligence. Judge Judy didn't need any further deliberation. The case was no longer about a scuffed bumper. It was about professional ethics and the sanctity of truth within the courtroom. "Judgment for the defendant, Mr. Sterling," she announced, the gavel striking the bench with a final, decisive thud. "Not only are you not liable for the $7,000, But Mr. Finch's client will pay the court costs associated with this frivolous, deceptive claim. She fixed Finch with a look of utter professional disdain. I suggest, counselor, that you spend less time tailoring suits and more time reading the documents you intend to present. Your lack of preparation, or worse, your intentional obfuscation, is an insult to this court and to the legal profession. Finch was ushered out, his earlier bounce replaced by the heavy, leaden slump of utter defeat. The viral moment was solidified the instant the footage hit the internet. The silence, Sterling's calm delivery, and the immediate, visible draining of color from Finch's face became the subject of countless clips and analyses. The segment wasn't just popular, it resonated with a deep cultural hunger for justice against the entitled elite who feel they can manipulate the system through noise and complexity. The comment sections exploded with praise for Sterling, often labeling the incident the quiet defeat or the rulebook revolution. The narrative wasn't about the law, it was about intellectual humility versus intellectual dishonesty. Sterling, the quiet plaintiff, represented the ordinary person taking the time to master the system that the professional had become too complacent and arrogant to respect. He didn't seek revenge, he sought only procedural accuracy, and in doing so he delivered a crushing moral and professional defeat. The lasting lesson wasn't about the importance of checking zoning codes, it was about the power of maintaining absolute composure when facing aggressive intimidation. Sterling never matched Finch's volume. He simply increased the factual density of his argument until the noise surrounding him collapsed under the weight of truth. His calm was not passivity, it was strategic control. He understood that in a confrontation involving rules, the quietest voice, armed with the precise citation, always carries the most devastating weight. He proved that sometimes the most humiliating response to a bully is not a shout, but a simple, accurate quotation of their own rules, followed by the sound of silence as they realize the game is over. The world needs more people like this. Share if you agree.